Good day, it is Stephen Davids here, and in this video and series of videos I will talk about harassment, the elements of harassment. This is the introductionary video. But first, in all the videos that I will make, and please ensure that you are familiar with the indemnity warning. And this is namely that I'm not a lawyer, and the information provided in this video and the others is based on my personal interpretation and understanding of the topic, and the laws and legal outcomes can vary depending on individual circumstances, and this video should not be relied upon as legal advice. So if you are dealing with a specific situation related to harassment or any legal matter, I strongly encourage you to consult a qualified legal professional for guidance tailored to your case. The Protection of Harassment Act 2010 is abbreviated as PHA, and there are two elements and main sections regarding harassment. The one is general harassment, like the workplace or private or whatever, and then you get secondly sexual harassment. These two differ, and you need to familiarize yourself with each one. This series of videos will deal with general harassment, but I'm sure that someone being charged with sexual harassment will learn a lot. I must also declare my bias in the sense that I regard this act, a PHA, Prevention of Harassment, as a very good act, and I fully support this act. Because the reason is that harassment, unfortunately, is very rife in our society, which sometimes is inherently violent. There's bullying at school, there's messages on WhatsApp, Facebook, etc. that people receive. Now, previously, you had to get expensive lawyers, and there was a long legal process before you could protect yourself and do anything about it. But now the things changed due to this law, and we are grateful for that. You can go to the court with your evidence that you are being arrested. You get a court order, and then there is a process following. So this video and others that follows are about the abuse of the Harassment Act by someone and for someone who feels I'm accused falsely. This, please, you must understand. And because this act can be and is also abused. Your initial reaction when you received an harassment order issue, or not necessarily the order itself, but correspondence, is you are livid, there's shock, there's frustration, there's anger. How can this be? What did I do? You may just feel, but man, leave everything. But please do not ignore the order or the summons to appear in court, because if you do ignore the order and the summons, the court may find against you. In your absence, you can get a court conviction on your record, your reputation suffers now because everyone says you're a convicted harasser, and someone who took you while you believe you are innocent, accused you falsely, took you to court. That person most likely has a mentality to abuse the system, now I got a court order against you, not within 100 meters phone, to go to a prison or whatever, to abuse it. So set out to defend yourself. Now, when someone applies for an harassment order, the magistrate can do one of two things. On the one hand, if the case appears to have some urgency, it appears there's some urgency and there's some merit, but I think this thing looks to me right, and then the magistrate will give an immediate restraining order. Now that immediate restraining order may prohibit you from doing some things. You may firearm if you have it, may confiscate it. You may not go to that person, contact that person, and then you'll also get an order to appear in the court on some date. Now this doesn't mean you are guilty, it just means it looks on the surface, prima facie, as a prerequisite. But on the other hand, if the case appears less urgent or less merit, there's person doesn't talk. I can't see really that. It applies to, but no, it doesn't look like this person has a case. The magistrate will order you to appear in court on a set date to explain your case. The court will not necessarily, I see this is not really a case, is very reluctant to refuse a case and to say an applicant can't talk nonsense at the start. They're very reluctant, it seems to me. They first want to determine themselves everything, come let the parties bring together and then see. So therefore, even if it is less urgent or that's not the best matter, it doesn't mean that they will just dismiss it outright. The fact that you didn't get an immediate urgent harassment order mustn't lull you into this false sense of security. So you are overconfident and neglecting the necessary steps to protect yourself. Ah man, the court said already, they could see it's nonsense. No. The final decision will be made at the hearing, and things may drastically change there because there are many cases where no interim order was granted, but then a final harassment order is given because the magistrate feels, man, after I learned now everything. This case has nogal merit. I put here an example, Sindizwe, Loveday, and you can read these cases. I will put cases there during the course of the series because I try to have the series at the academic level also, so that you can protect yourself with confidence, and so that you can read up the cases themselves. Now there are one of two ways to protect yourself. You either get a lawyer, pay up, problem is solved. If the other party has a lawyer, the court will strongly urge you to get a lawyer to level the playing fields, because there are some certain procedures and certain terminologies and sometimes that lawyers use and things, how things must be done. It's not impossible, but it's much better if you get a lawyer. Or you can defend yourself. You must defend yourself either personally, or you can try to get legal aid. Legal aid, and sometimes legal aid does not want to help you because you don't qualify, or you can't really afford a lawyer, but you are just outside the field of the legal aid. Legal aid is sometimes so full of nonsense, and this is why I made this video. So this video is whatever, if you defend yourself, if you get a lawyer who knows more the intricacies of these procedures of the court, this is what will happen. Familiarity is always a very good thing. You can't go and familiarize yourself with a process by, for example, go to an open court and sit in there, because these things are done more sometimes in private. So this video is for you so that you can keep an eye on your lawyer. You must not pray for your lawyer also, and pray that God guides your lawyers to protect you and give them, or he or she, wisdom to protect you, and so that you can also defend yourself. This is as a mutual purpose. Now, the number of court appearances, according to DeepSeek, on average there may be between 3 to 6 court appearances. The course may also last up to 1 year. So you're in for the long haul. And each appearance will take time to prepare. Well, you must travel to court, you must sit there, wait at the court before the magistrate. So you must just prepare yourself, not whoops, in and out. You must take all your evidence to court. Rather be over-prepared than being under-prepared. Take enough evidence to the court. It's like overkill and underkill and no use you come in court. Ooh, Nada, I forgot this thing there. Oh, I wished I had this. And take then, if you have to take your evidence, written or whatever, try to have more than one, maybe 4 copies. 4 copies, 1 copy for you, 1 copy that you give to your lawyer, 1 copy that you can give to the magistrate, and 1 copy that you can give to the opposing partner, should things develop that far. But always keep things. And also, remember, the court will only decide based on the evidence provided. There's this quote, orders are to be granted purely on the strength of the available evidence presented. The court, you must assume, don't know anything. The court has many things. The court can't assume. The court only knows what you tell them, what you present to them. So don't keep quiet. You have your evidence here. It is irrelevant. The court will not smell it. You want something that must be done? Your Honor, this is, I want to show you that you must tell the court. Even if you wrote it down and submit it as a written evidence, repeat it. Because you are dealing with people. And then there's another thing, that the court is based its outcome on the balance of probabilities. Now, according to Copilot, because I use artificial intelligence a lot in these videos for research and everything, the balance of probabilities is a standard of proof used in civil cases. It means that a court decides an issue based on what is more likely to be true or not. In other words, if there's a greater than 50% chance that the claim is true, someone says, and it meets the standard, so you go for it. Now, this is far less stringent than in a murder case. Beyond all reasonable doubt, you must show that a person murdered the other one. No, this is more, man, do I get the feeling that this person is talking the truth or not? Whoever defends himself or whatever. Now, the balance of probabilities is both a blessing and a burden. And a blessing because the accused does not have to prove their innocence beyond a reasonable doubt. Ne? I only have to weaken the applicant's case significantly. And I will show enough doubt so that the presiding officer, the magistrate, can say, no. But this person talks nonsense. He is really not such a lot of proof that this guy is guilty in front of me. However, it's also a burden. Ne? Because the applicant does not need to prove his and her case beyond all reasonable doubt. They only need to convince the magistrate, no, I've got a reasonable doubt. What I say is reasonably true, that this harassment occurred. Now, an example of the probabilities, balance of probabilities approach is a complainant, accuser, claims that their neighbor sent repeated threatening messages. Well, the neighbor denies it. Now, both parties are present in court, and the complainant provides screenshots of messages and testimony about what this was caused. And now the neighbor comes and argues about the messages were fabricated, and he come and present testimonies from friends as a support. And then the judge come and evaluates all the evidence and testimony. And to decide based on balance of probability, they just ask, is it more likely than not that the neighbor sent the threatening messages? If the complainant's evidence is more convincing and more credible than the neighbor's denial, even slightly tipping the scale, you will rule in favor of the complainant. Please like and share this video, and please subscribe. Thank you very much for watching this video.